Exam Scholar, Real Estate Edition.
Question 1. What special type of ownership is available in most non-community property states and is only available to married persons? A. Estate by escheat. B. Tenancy by the entirety. C. Dual tenancy. D. Coup estate. Answer. B. Tenancy by the entirety is available in most non-community property states and is automatically the assumed form of ownership when a couple purchases real estate together unless they opt for another form. Question 2. If a restaurant is located in a section of town that has been rezoned from restaurant and retail to commercial office building development, the restaurant can remain there by use of A. A special use permit. B. Non-conforming use. C. The grandfather use clause. D. Tenancy in specuity. Answer. B. The restaurant can remain in place by non-conforming use. The restaurant will not be able to expand into other neighboring sites, however. Question 3. A broker gives a written step-by-step instruction manual to new agents and instructs them to follow each of the steps exactly in order to produce sales for the brokerage. In addition, the broker threatens to discipline any agent that does not follow the steps, up to and including termination. The agent should A. Be scared of losing the position in the brokerage by means of firing. B. Follow the directions step by step. C. Do what they feel is best for obtaining results for the brokerage. An agent is an independent contractor and liable for results only, not the means they are achieved. D. None of these. Answer. C. A real estate agent working under a broker is liable to the company only for the results achieved as defined in the hiring contract and not by the specific means they are achieved. This is an independent contractor arrangement. If it were an employer-employee relationship, the employer can dictate the specific means of obtaining performance. Question 4. To match the specifications of a subject property, in the market data approach to appraisal, the sales prices of comparable properties are A. Increased. B. Decreased. C. Adjusted. D. Net zeroed. Answer. C. In the sales or market data approach to appraisal, the sales prices of comparable properties are adjusted to match the specifications of a subject property. Question 5. In real estate, the simplest form of property ownership is called A. Joint. B. Tenancy in common. C. Community. D. Severalty. Answer. D. The simplest form of ownership in regard to real estate is severalty because there is only one owner. All other forms include multiple party owners involved. Question 6. What is the formula for determining the value of an investment property? A. Net operating income divided by capitalization rate. B. Capitalization rate multiplied by net operating income. C. Potential gross income divided by operating income. D. Potential gross income divided by capitalization rate. Answer. A. Net operating income is divided by the capitalization rate to arrive at the value of the property. Question 7. If a buyer decides to pay for a property in cash, which form is required to be filed according to the IRS? A. Form 1090. B. Form 9600. C. Form 8300. D. Form 2740B. Answer. C. IRS Form 8300 must be filed on all cash payments that are $10,000 or more. Question 8. A cash payment of $10,001 is given as earnest money to secure a property. What must be filed? A. A documenting receipt. B. A procurement contract. C. An IRS Form 8300. D. An expediting loan form. Answer. C. The IRS requires any cash payments over $10,000 be recorded by filing a Form 8300. Question 9. A vendor-vendee is a term that best describes the relationship between A. Purchase and sales. B. Mortgager-mortgagee. C. Grantor-grantee. D. Optioner-optionee. Answer. A. The term vendor-vendee is best matched with purchase and sales. Question 10. Which term is best related to lender-borrower? A. Grantor-grantee. B. Mortgager-mortgagee. C. Optioner-optionee. D. Seller-buyer. Answer. B. The best match from this list that is related to lender-borrower is mortgager-mortgagee. This relationship is a lender-borrower relationship. Question 1. If a minority person is looking to purchase a home and the lender refuses to lend to them based on their creditworthiness, this is A. Legal. B. Racial profiling. C. An example of blockbusting. D. Illegal. Answer. A. A lender is not required to lend to any person that does not meet the requirements of creditworthiness. Question 2. When a real estate developer obtains a loan for building a new housing tract and the lender gives part of the funds to the developer and agrees to release the rest of the funds as each home is built, this is called which type of financing? A. Earnest money. B. Fixed amount. C. Obligatory. D. Chronological release. Answer. C. In this type of situation, this financing is called obligatory financing or also called fixed disbursement schedule. Question 3. A reconveyance deed is used in connection with A. A life estate sale. B. A trust deed sale. C. A valid transfer of ownership in any property. D. None of these. Answer. B. A reconveyance deed is used in connection with a trust deed sale by a trustee to a trustor after a loan has been paid in full. Question 4. In order to form a valid contract, which is not necessary? A. Performance. B. Consideration. C. Offer. D. Acceptance. Answer. A. Even though an offer has been placed, the offer accepted, and consideration put forth, there is no guarantee that either party will perform the obligations of the contract. Performance is not a necessary part of forming a contract. Question 5. In regards to contracts, if part of a contract is written and another part is printed, which part takes preference? A. The typed part. B. The written part. C. None. Contracts must be typed. D. They are both equal. Answer. B. If part of a contract is written and another part is typed, the written part takes preference over printed parts. Question 6. If a contract is written and parts are incomplete or ambiguous, what type of agreement takes preference? A. An oral agreement. B. A new typed agreement. C. A new written agreement. D. None of these. Answer. In this case, if a contract is written or typed but is ambiguous or incomplete, an oral agreement then takes preference. This is true only if the original contract is ambiguous or incomplete. Question 7. If a person wishes to obtain a chattel mortgage, they would need to put up A. Personal property as collateral. B. Another property as collateral. C. Any type of property as collateral. D. None of these. Answer. A. A chattel mortgage is a mortgage that is secured by personal property. Question 8. A real estate broker is typically considered A. An agent or fiduciary of the principal. B. An attorney in fact. C. To have the power of attorney. D. None of these. Answer. A. A real estate broker is typically considered an agent or fiduciary of the principal. A broker does not have power of attorney unless the principal grants him/her that right. Question 9. If a broker notifies a seller, of whom the broker is working with by means of listing, of a prospective buyer, this creates what to entitle the broker to a commission. A. Procuring cause. B. Prior notice. C. Fiduciary relationship. D. Accelerated notice. Answer. A. If a broker notifies a seller of the identity of a prospective buyer of a listed property of a client the broker is working with, this constitutes procuring cause. If the seller were to then go to the prospective buyer later without the broker's knowledge and make a deal, the broker would still get the commission due because the broker was the procurement source of the buyer. Question 10. The bulk sales law is included in A. The habendum clause. B. The caveat emptor clause. C. The Uniform Commercial Code. D. The governing laws of commerce. Answer. C. The Uniform Commercial Code includes the bulk sales law. Bulk sales laws are intended to prevent business owners from defrauding or evading creditors by transferring all, or a substantial portion, of the assets of the business to another individual or entity. The law is also intended to avert the possibility of businesses selling their assets below fair market value in a sweetheart sale, in which the owner of the business manages to maintain a degree of control. Question 1. If the expiration of time has passed in regards to the communication of acceptance by the seller from the buyer, this offer is considered A. Terminated. B. Valid. C. No longer an offer. D. None of these. Answer. A. One way to terminate an offer from a buyer by a seller is to let the time expire on terms of acceptance. Question 2. In real estate, the offer to perform on the terms agreed is called A. Tender. B. Performance. C. Negotiated. D. Acceptance. Answer. A. An offer by one of the parties to a real estate transaction to carry out that party's part of the contract is called the tender. This typically takes place at the end of the transaction. Question 3. If one party cannot perform their part of the agreed terms of a contract, the victim party can claim the other party. A. Performed negligently. B. Defaulted. C. Is voiding the contract. D. Is causing interference. Answer. B. If a party cannot perform their part of the agreed terms of a contract, the other party can claim the other party defaulted. Question 4. If a party was discriminated against, they could A. Bring private action through a state or federal court. B. Bring criminal action through a state court. C. Bring criminal action through a federal court. D. Bring civil action through a state court. Answer A. Because discrimination is not considered a criminal act, the option of the party would be to bring private action through a state or federal court. Question 5. If a buyer of a property wishes to move into the newly purchased home before the close of escrow, the agent/broker should A. Allow it. B. Deny it. C. Obtain written consent from the owner. D. None of these. Answer C. Because the home has not closed escrow, it is still owned by the current owner and therefore the agent/broker must obtain written consent to allow the new buyer to move in before the close of escrow. Question 6. A legal cause of action in which a binding agreement or bargain for exchange is not honored by one or more of the parties to the contract by non-performance or interference with the other party's performance is known as A. Breach. B. Non-disclosure. C. Voidable. D. None of these. Answer A. Breach of contract is when one party does not honor the agreed upon terms of a contract by non-performance or interference with the other party's performance. Question 7. A clause that states a lender may demand the loan amount plus accrued interest in the event of a sale is called A. Addendum. B. Non-performance. C. Acceleration. D. Alienation. Answer D. The clause in which a lender may call in the loan plus accrued interest in the event of a sale is known as alienation. This is different than an acceleration clause in which the loan can be called in due to non-performance of contractual duties, such as not paying mortgage payments. Question 8. What type of arrangement is a less than freehold estate? A. Owner/tenant. B. Tenant/sublessee. C. Lessor/sublessor. D. None of these. Answer A. A less than freehold estate is an owner/tenant arrangement. Question 9. If an as-is clause is inserted into the sales contract for a property that seems to be generally okay on the outside and inside, this would be A. Allowed. B. Disallowed. C. Allowed only in cases of obvious defects. D. None of these. Answer C. The only way an as-is clause is allowed in most situations is if there are obvious defects that any prudent person could discover. Typically they are disallowed by the real estate commissioner to protect consumers. Question 10. If one is transferring or conveying title to real property, it is called A. Alienation. B. Alluvion. C. Accretion. D. Succession. Answer A. The term alienate in real estate means to convey or transfer. Question 1. An index used to determine interest rate changes for certain adjustable rate loans is called A. Treasury index. B. Rate index. C. Adjustable index. D. Interest index. Answer A. The Treasury index is an index used to determine interest rate changes for certain adjustable rate loans. Question 2. A written justification of the price paid for a property, primarily based on an analysis of comparable sales of similar homes nearby, is called A. A comp. B. An appraisal. C. A similar analysis. D. Neighborhood investigation. Answer B. An appraisal is a written justification of the price paid for the property. Question 3. The property that will be pledged as collateral for a loan is known as A. Security. B. Pledge. C. Promise. D. Collateral. Answer: A. In this case, the security is the property that will be pledged as collateral for the loan. Question 4. The buying and selling of existing mortgages, usually as a pool, is called A. Primary market. B. Secondary market. C. Tertiary market. D. Market index. Answer: B. The secondary market is the buying and selling of existing mortgages. They are usually sold as a pool. Question 5. Ingress or egress means the right to A. Enter or leave designated premises. B. Buy or sell designated property. C. Exclude or include individuals from a designated property. D. None of these. Answer: A. Ingress or egress means the right to enter or leave a designated premises. Question 6. A tenant is excused from paying rent in the event of fire or casualty damage and the landlord receives uninterrupted income while the premises is unusable by means of A. Rent loss insurance. B. Hazard insurance. C. Rental insurance. D. Property insurance. Answer: A. Rent loss insurance covers a landlord for lost rent in the event of casualty damage while the premises is unusable. Also, the tenant is excused from rent for this period. Question 7. The noting in the registrar's office of the details of a properly executed legal document, such as deed, mortgage note, satisfaction of mortgage, or extension of mortgage, thereby making it a part of the public record, is called A. Recording. B. Notation. C. Delivery. D. Registration. Answer: A. Recording is when the details of the properly executed document are noted in the registrar's office, making it a matter of public record. Question 8. A purchase money transaction is A. The acquisition of property through the payment of money or its equivalent. B. The acquisition of property through the securing of sufficient loan amount. C. The acquisition of property through the promise of sufficient collateral. D. The acquisition of property through the payment of equal property. Answer: A. A purchase money transaction is the acquisition of property through the payment of money or its equivalent. Question 9. What does PITI stand for? A. Principal, interest, taxes, and insurance. B. Property, income, taxes, and insurance. C. Prime, income, tenement, and insurance. D. Principal, income, taxes, and insurance. Answer: A. PITI stands for principal, interest, taxes, and insurance. They are the four components of a monthly mortgage payment on impounded loans. Question 10. The four components of a monthly mortgage payment on impounded loans are A. Principal, interest, taxes, and insurance. B. Property, income, taxes, and insurance. C. Prime, income, tenement, and insurance. D. Principal, income, taxes, and insurance. Answer: A. PITI stands for principal, interest, taxes, and insurance. They are the four components of a monthly mortgage payment on impounded loans. Question 1. Which of the following real estate syndicates requires 100 or more investors? A. Limited partnership. B. Joint venture. C. Corporation. D. Real estate investment trust. Answer. D. A real estate investment trust, which is organized under federal laws, must have 100 or more investors. Question 2. A purchaser of real property utilizing leverage is A. Using the maximum amount of his own money to purchase property. B. Using the maximum amount of borrowed money to purchase property. C. Making the maximum down payment for the property. D. None of the above. Answer. B. Leverage is the use of credit, borrowed money, to purchase a property. When a property is 80% leveraged, it means a debt on the property is 80% of its value. The owner's equity is 20%. Question 3. A licensed contractor purchased 8 lots in a new subdivision and constructed 8 homes on the lots. He sold the 8 homes to various buyers and took back a $5,000 second trust deed on each of them. He would now like to sell the trust deeds within the year of their creation at a 20% discount. In order for him to do this, he A. needs a real estate license. B. must sell them through a real property securities dealer. C. does not need a permit. D. must deliver a real property security statement. Answer. A. These second trust deeds are classified as promotional notes and are real property securities. The contractor must obtain a permit to sell them, and since he is handling 8 in one calendar year, he is considered to be in the business and must have a license to sell them through a licensee. A dealer's endorsement is not required. Question 4. Which of the following statements is correct concerning a land contract? A. It is used when the seller wishes to convey title without a trustee relationship. B. It is similar to a lease in that the buyer has a right of possession but no rights in the title. C. The buyer has absolute assurance of receiving title upon performance of the contract. D. It is the least secure method of financing real property for the buyer because the seller has retained the title and the buyer is merely the equitable owner. Answer. D. A land contract is a security device used in financing real property, but it is the least secure method for the buyer, since the seller does retain the title. The buyer is the equitable owner, which means that he can use the property. While the seller retains the title, the buyer has rights in that title, and he often records the land contract to give public notice of those rights. Question 5. The liquidity of a borrower is generally determined by a loan officer in considering A. Debt to equity. B. Income total assets. C. Current assets to current liabilities. D. Fixed assets to current assets. Answer. C. A loan officer, in determining the liquidity of a borrower, is attempting to determine his ability to pay off current bills. Current assets to current liabilities would be the test he would use. Question 6. The owner of a property who signed a listing with a broker for 30 days was killed in an accident before the listing expired. The listing is A. No good as an authorization but binding if a buyer is secured later. B. Still in effect as the owner's interest was clear. C. Binding upon owner's heirs to carry out his promises. D. Terminated by the death of the owner. Answer. D. All personal service contract, such as listings, are terminated immediately upon death of either party. Question 7. Which of the following would usually be considered real property? A. Timber. B. Airspace above the land. C. Unharvested crops already contracted for. D. Land-filled dirt being moved. Answer. B. Of the choices given, airspace above the land is considered real property. Question 8. Conventional loans are distinguished from FHA-insured loans by all of the following except A. Conventional loans provide for a lower loan-to-value ratio. B. FHA loans generally provide for a longer repayment period. C. Conventional loans always permit a deficiency judgment, while FHA loans never allow them. D. Interest rates on FHA loans are generally lower than those on conventional loans. Answer: C. Deficiency judgments are not allowed on purchase. Question 9. Brother and sister purchase property as joint tenants. Later, the sister marries and deeded her interest to herself and her husband. A. The joint tenancy continues to exist in all three persons. B. The brother remains as a joint tenant. C. The joint tenancy is terminated. D. The sister's deed to her husband is voidable by the brother. Answer: C. Joint tenancy require the four equal unities of time, title, interest and possession between two or more parties. Once any of the four unities is broken, it can no longer be a joint tenancy. Question 10. Theft as it relates to real property includes all of the following except A. Entering and removing part of the realty. B. Defrauding by misrepresentation. C. Signing another's name without authorization. D. Carrying away any portion of the security of a mortgage with the intent to defraud the mortgage. Answer: C. Signing another person's name as forgery. It may lead to theft in our way of thinking, but is not defined as such in the Penal Code.
Exam Scholar, Real Estate Edition.